when you begin any event to do a welcome, what we call a welcome to country, to acknowledge our Indigenous peoples who are the custodians of the lands that we are. I'm assuming this is something that is important for everybody in the room. It's extraordinary for me to think that in my country, people have lived here for 65,000 years and counting. So that's over 2,500 generations. And our Indigenous people, but no doubt Indigenous peoples around the world, also have interesting perspectives on space. And so we welcome all Indigenous people to this broadcast. We've got a wonderful panel. I'm honoured to introduce you to them in a minute. But I should make a couple of housekeeping points and one other important point before we start. This panel does not reflect the range of men and women from all the different backgrounds who have important things to say about humankind's adventures to the moon and beyond. And sometimes the space industry struggles to hear the full range of well-informed voices from diverse backgrounds, and I'm conscious that perhaps we are inadvertently shining a light on that today. Rest assured, this is a discussion that's part of a wider range of engagement between all of us as human beings in the space community. That said, we've got a wonderful panel and I'll introduce them in a minute. Housekeeping rules. All of your mics are on mute, but we would love to have your questions. There is the typical chat function, and those questions will be monitored and sent through to me to pass on. We'll be together for about 2 hours. What we plan to do is allow each of our speakers to speak for 15 minutes. Then we'll open the floor up for questions from you, and perhaps the panelists might be asking each other questions as well. And then we'll have a wrap up and end, as I said, in about 2 hours' time. It's a long webinar, but I'm sure you'll find it a fascinating webinar. Obviously, issues around the Artemis Accords, which were made public, the principles of which were made public in the middle of May by the US administration, by NASA, have raised a lot of discussion. They're another incredibly important input to a broad global discussion on issues relating to our adventures back to the moon and beyond. They involve issues relating to resources, peaceful uses of space, cooperation and interoperability, emergency assistance, mitigating space debris, really important principles. But they are a new set of inputs, even though they are centered around important instruments like the Outer Space Treaty. And so we've got people to talk about the antecedents of the Artemis Accords, why they've been promulgated, what they say, and then how the Artemis Accords might interact with other aspects of the regulation of space. We have 5 speakers, although I'm not sure whether Mike has yet made it with us, but we've got 5 really expert speakers. Mike Gold, the Acting Associate Administrator of the Office of International and Interagency Relations at NASA. Mike was having some technical issues, so hence our delay in starting. My apologies. We have Professor Jakhu, Associate Professor from the Faculty of Law at McGill University. We have Gabriel Swiney, Attorney Advisor from the United States Department of State. André, the former head of program of the Legal Services Division at the European Space Agency, and Tommaso Sgobba, the Executive Director of the International Association for Advancement of Space Safety. As I said, I will ask each of our panelists to speak for 15 minutes. I'll give them a little nudge when we're getting to close to the 15. And in the meantime, if you have questions, we would welcome all of them. Put them in the chat, we'll monitor them, and then we'll get to them as quickly as we can. Mike, I can't see you, but are you with us, Mike? Mike Gold?
Can you hear me, Steve?
Oh yes, is that Mike? Welcome. I'm sorry you've had technical issues. I know you're now on the phone. Mike, are you in a position where you could make your presentation now anyway, given the technical difficulties?
Yeah, I think I could, if Kiran wouldn't mind bringing up my presentation, I could talk you through it.
Absolutely. Okay. As I said, we have Mike Gold. We're honoured to have you with us. Thank you, Mike, for joining us in your busy schedule. The Acting Associate Administrator of the Office of International and Interagency Relations at NASA. Mike, the floor is yours for up to 15 minutes.
Great. Thank you so much, Steve. I appreciate McGill and ISL and the invitation to participate. Unfortunately, you can't see me, but trust me, I look absolutely fantastic. So if you can all put that in your imagination, terrific today. And I'm hoping Kiran can bring up the slides. And the first slide is wonderful. Slide number 1, humanity's return to the moon. So what I thought I would do today is take you through a little bit the Artemis program to begin with, because there's no Artemis Accords with program, and then describe a little bit the high level, what we're looking for out of the Accords, and then Gabriel Swiney will get into more of the details of the principles of the Accords. So as always with NASA, we're acting as a team with Department of State. If we could go to the second slide, please. The goal of the Artemis program is to put the first woman and the next man on the moon by 2024. And here in this slide, you see the components of Artemis, at least the major ones, beginning with the Space Launch System, which will be the most powerful rocket built by humanity. Next to that is the Orion capsule, which has already flown in space and will carry not only our astronauts, but astronauts from our international partners to the moon. And then finally, on the far right, you see an astronaut getting out of a human lander. I included that because we just received over $600 million from the House Appropriations Committee for the Human Landing System. As a lawyer and someone who follows congressional affairs pretty closely, I sometimes think that the engineering can be the easy part, but it's the politics that can be very challenging with a program like this. And that's why it was such an incredible milestone to receive over $600 million landing system. A human lander for the moon has only received this level of funding twice, once for Apollo and once for Artemis. And we're just thrilled with the bipartisan support that we're seeing for the Artemis program. Very grateful to the administration and the Congress for coming together and everyone supporting this incredible vision for human space flight and exploration. Going to the next slide, please. Number 3. I wanted to take just a minute to talk about the differences between the Apollo program and Artemis. And even going to the name, it begins with diversity. That, of course, there were no women with the Apollo program, yet the very goal of the Artemis program is we're going to have the first woman on the moon. That's where the name Artemis actually came from, as the twin sister of Apollo. And I want to say that that diversity is not only the right thing to do morally, but it drives innovation, that the more different kinds of people you have, the more differing views that you can bring to try and resolve a problem, the more you're going to innovate, the better ideas you're going to have. So I think we're going to do even better with Artemis than we did with Apollo, because we're going to have so much more diversity in terms of not only the astronauts, but the engineers, the scientists, and the entire team that will support the Artemis program. And in terms of those astronauts, I'm proud to say that I believe we have the most diverse astronaut corps currently in the agency's history. So there's a substantial difference in people, which I think will benefit in terms of better innovation due to that diversity. We're also going to have a much greater diversity of countries. That Apollo was, of course, primarily an American program. And to be clear, Artemis will be American-led, but there's going to be a global coalition that will be involved in Artemis that will join the US in this journey to the moon. And that will not only include many of our traditional partners that have worked with us on the International Space Station, but I'm so proud that Artemis will open up the opportunity for us to engage with many of the new emerging space agencies. We've seen a proliferation of new space agencies coming from various countries. The United Arab Emirates is a great example of a relatively new, I don't know if I can quite call them new anymore, space agency that's come so far in such a short amount of time. And I just want to give them some kudos for their upcoming HOPE mission, very aptly named, that's going to be launching to explore Mars on July 14th here in the US. So coming up very soon. So as we move forward to the moon with Artemis, there's going to be many countries more involved in very substantive ways to partner with us on this journey of discovery, very different than what occurred in Apollo. Also different is commercial, that there's a whole new robust sector of commercial contributions. I'm sure many, if not all of you, watched the Demonstration Mission 2 commercial crew launch. First time we launched American astronauts on a commercial system. During the first operational launch of the next commercial crew flight, we'll have a partner astronaut, Soichi Noguchi from Japan. So immediately on the first operational flight of our commercial systems, we're carrying not only Americans, but international astronauts going up. And that commercial capacity, that commercial innovation is going to be leveraged to bolster the Artemis program. And then there was an end to Apollo, and there should never be an end to Artemis, just sustainable development. And if I could go to the next slide, please, the gateway. The very cornerstone of the gateway system, which is an orbital outpost around the moon. The first modules of Gateway will be deployed and built by the US, in particular, the power and propulsion element, which will provide the propulsion, as the name indicates, and the energy for the system, as well as some communications capacity. And then HALO, which is a small habitat. Those systems will be launched in 2023. And then very soon, they'll be joined by the IHAB, the international habitat that's being developed by the European Space Agency in Esprit, another ESA contribution that will support some refueling capacity. Additionally, Japan, via JAXA, will be making contributions for subsystems for Gateway, ECLIS, environmental control life support, and batteries for both IHAB as well as HALO. So you can see with Gateway, not only do we have a system that will allow us to create infrastructure to sustain our presence around the moon, to gain understanding and experience with deep space systems that will lead to more robust exploration, more robust science, both in cislunar space, lunar orbit, as well as on the surface of the moon. We'll be able to do much more ambitious exploratory, also gain the critical experience that we go on to Mars. So Gateway is very aptly named because it not only is going to be our gateway, our passage to the surface of the moon, but to Mars and the rest of the solar system. Moving on to my next slide, this should be the Canadian $5 bill. I would be remiss if I didn't mention one other international contribution to Gateway, particularly the robotic arm that I believe the Canadian government just gave an award to the company to build. And I've always appreciated Canada, and since we're talking at a McGill event, I couldn't help but note that Canada is the only country that has its ISS contribution on its currency. So I've always been very jealous of Canada, although I've always wondered why on the 5 it's only the arm, there's no space station. And As a former export control attorney, also I'm concerned that Canada might have the only currency that could be a ITAR violation potentially, but applaud Canada for its contribution and its long history in robotics. And again, another country that's making these contributions to the Gateway and the Artemis program. Going to the next slide, please. So I want to mention, and again, it's a good SIG in terms of the robotic arm and what's been done on the International Space Station, where, again, Canada and the robotic arm have been an extremely important part of our program. And I do want to mention the ISS, because that international collaboration is not only a foundation for what we're building in cislunar space and onto the Moon and Mars technologically, but also from a legal perspective. That, as I'm sure many of you are aware, the International Space Station's legal framework is the Intergovernmental Agreement, the IGA. We will be leveraging the IGA for Gateway. So we're working with our partners on a series of MOUs that will be used to operate the Gateway. Again, there's some strong similarities, of course, between what we need to do when operating a space station in low Earth orbit to operating around the Moon. So the IGA is very applicable to that in a document that we'll be leveraging. However, if I could go to the next slide, please, the Artemis Extending Lunar Missions Prepare for Mars. You see here that it's not just Gateway, but we're going to have a robust presence on the lunar surface. And there you can no longer apply the IGA, that we need a new legal framework to be able to support the surface activities, be it rovers or habitats, power stations, new terrain vehicles. All of these activities, of course, cannot be done under the IGA. Therefore, as NASA looked at the dynamic new opportunities that Artemis will present, we needed a dynamic new legal framework to support international partnerships under the Artemis program. And I just want to emphasize, at their core, this is what the Artemis Accords are for, and this is what they are: a series of bilateral agreements to enact partnerships in support of the Artemis program. Not overly different than our traditional international partnerships that you see NASA execute around the world for a variety of programs. But there is a difference in that with the Artemis Accords, we're leaning more forward relative to a series of principles that we will want our international partners to adopt to create a safe, secure, transparent, and more prosperous future for all of us. There has been an overwhelming amount of support for the Artemis program from the international community that we've been extremely grateful for. But because of the popularity and the desire of many countries to participate, we think we've got an opportunity to say, if you want to join us in this program, there are certain principles, again, that we would like you to abide by. If we can go to our next slide, it's a picture of the Moon, but just in the interest of time, let's go to the next slide after that, which should be Artemis Accords principles. So here you see that we've got a series of principles that Gabriel will go into more detail that we are going to ask the partners who join us with Artemis to support. These principles, as you see, are grounded in the Outer Space Treaty. In many ways, the Artemis Accords are an homage to the Outer Space Treaty and honoring and implementing our obligations underneath the Outer Space Treaty. That being said, there are a number of principles that do go a step further and maybe in the spirit of the treaty, but aren't in the text itself. Say a principle, for example, such as the release of scientific data. NASA has always publicly released its data. That's been very important to the agency, so that not only NASA, but the whole world can enjoy the benefits of our exploratory activities. Very much in the spirit of the Outer Space Treaty, but not required. Then there are areas in the Artemis Accords where we implement the obligations of the Outer Space Treaty. The deconfliction of activities is a good example of that the Outer Space Treaty states that we should avoid harmful interference. Well, how do we do that? The Artemis Accords go into a bit more detail where we talk about, for example, safety zones. the surface of the moon or elsewhere in cislunar space, where within that area, if you had an operation that could potentially cause harmful interference, that area you would want to have notification, as required by the Outer Space Treaty, and coordination to avoid harmful interference. We think that those are two very modest steps and logical steps, things you would have to do anyway underneath the Outer Space Treaty to actually implement the obligation for avoiding harmful interference. There are a few other areas where we lean forward beyond the treaty, such as protecting heritage sites, which we think is very important. We protect our artifacts here on Earth. We should do so in space. As well as, we take cues from other multilateral agreements for rescuing astronauts, where we talk about emergency assistance, etc. So as you can see, these are core principles that we believe are very inclusive, that any responsible space actor who has executed the Outer Space Treaty should be able to abide by the Artemis Accords. As we were crafting the Accords, we worked very hard to make sure that they were as inclusive as possible, implemented the obligations of the Outer Space Treaty, so that even if a country didn't join, if you're a member of the Outer Space Treaty, a signatory, you would have to abide by a great deal, if not almost all, of these different aspects and principles. Additionally, while we have draft text, we of course need feedback from our international partners, and over the past 6 months, we have had robust conversations that have led up to the draft text of the Accords, and now we're finally engaging with our international partners to get their feedback on draft text of the Accords, because we certainly don't know it all. Just like the negotiations for the IGA and what we've done in the past, we need to engage with our international partners to get their feedback, to get their ideas. The Artemis Accords will be much better documents and much improved as we receive and integrate the feedback from all of these different countries. I should say the Accords will be bifurcated, that there will be the principles section that will be uniform for all of the countries that join us, and then there will be an annex or an implementing arrangement that will describe the actual specific activity. So if it's a partnership between the US and, say, for example, Canada on a rover, the principles section would be the same that we would have with Canada or any other country, and then the annex would describe the actual activity, which would be different and might have some different clauses relative to liability, etc. What I'm excited about with the Artemis Accords versus the IGA is that there's so many more countries involved. With the IGA, you really just had the big four, if I'm counting correctly, with the European Space Agency, CSA, JAXA, Roscosmos. Again, with the Artemis Accords, we're able to integrate these new emerging space agencies and still work with our existing allies, but in many ways that makes it more challenging than the IGA, because we're getting feedback and integrating input from so many more countries. So this is going to be a bit of a lengthy process. It already has been as we solicit this feedback. However, due to the way the Accords adhere to the Outer Space Treaty and then support common sense principles, beyond that we think should be universally acceptable, such as the public release of scientific data, the process has actually been going quite well. We think that there's a lot of common ground that all of these countries can agree on. And myself and my team at NASA, as well as Department of State, who have been terrific partners with this, we've really developed the Artemis Accords together. Gabriel, Swiney, who you're going to hear from in a moment in particular, has done a tremendous job with the Accords. But they're getting better every time we meet with these international partners and get their feedback. So it's been a robust process to integrate the feedback from the international community and create a document that can be owned by all and we can all be proud of. So Mike, going to the next slide.
Mike, could I just ask you to sort of close up in a minute or so?
Yep.
So we can
I will absolutely wrap up. Let's go to the last slide.
Thanks,
in
Mike.
the end, what we're trying to do with the Accords is prevent conflict at its very core. The first part of the Accords is for peaceful purposes. That is exactly what we are trying to achieve, that we need transparency, we need people to understand what each other is doing so we can avoid trouble. And as a science fiction fan, I couldn't help but end with the plea that that's why we're doing the Accords. We need to be more Star Trek and less Star Wars. So with that, Steve, I'll shut it down and turn it back over to you.
Mike, thank you very much, and my apologies for interrupting there, but we want to give lots of time for the questions. Some questions are beginning to come through, so please send your questions in the chat. Mike, thank you very much for presenting that that outline of the main goals behind what the Artemis Accords have proposed to achieve. Thank you. Following on from that, I'm delighted now to ask my good friend Gabriel Swiney, attorney advisor from the US Department of State. I know him well from COPOS, but he does many other things as well. Gabriel, thank you very much for joining us. We're delighted to have you. The floor is yours for 15 minutes.
Thanks, Stephen. And hopefully I won't take 15 minutes. Mike has already done a great overview of what the Artemis Accords are and why we're doing them. So I'll try to focus instead on a little bit more of a legal perspective on what they actually would do and how we've gotten to where they are. So Kiran, if you could start my slideshow, that'd be great. And as we're waiting for that to come up, I should say, as you heard, I'm an attorney advisor at the Department of State, so I cover the international space law side of things for the State Department. And I work closely with Mike, as he said, on Artemis and Gateway and lots of other things. Okay, so the Artemis Accords. Let's move on to the next slide, Kiran. So, and I should apologize, my PowerPoint skills are not as great as those at NASA, so you'll have to bear with me for my PowerPoint. What's the motivation? I think Mike already covered this a little bit from a policy side, but I can talk a little bit about what the motivation is from the perspective of an international space lawyer such as myself. And it really is responding to needs of operators, and in particular responding to the needs of NASA and responding to the needs of our civil space partners around the world. What I mean by that is, we, the Department of State, and sort of the international space law community, we have been seeing what's coming in the near term in terms of the Artemis program, in terms of other activities, exploring the moon and moving on to Mars. And we recognize, or I recognize, and my colleagues and I recognize, that these are new kinds of activities. Yes, we've been to the moon before in the Apollo program, but as you all know, we didn't stay for particularly long. There wasn't infrastructure built. There wasn't long-term exploration. So what we're looking at now in the near term as part of the Artemis program really is a new thing, to have sustained presence on the moon in cislunar space and then moving on to Mars. So given that we're doing something new, something that humanity has never done before, the question, right, a good lawyer would ask themselves is, does that raise new questions, new legal questions? Do we need to resolve new legal questions, or legal questions that we frankly haven't had to resolve for 50 plus years? And the answer was yes, right? There are questions and issues that are likely to come up because of the nature of these activities that we simply haven't had to address. Things like deconfliction of activities when multiple actors might be operating in close physical proximity to each other, say on the lunar South Pole. That's something that's never happened before. So that's an issue we might have to deal with. Rescue and emergency issues far away from low Earth orbit, another thing we haven't had to deal with before. Space resources, another one. So we have a whole range of issues that we frankly don't have clear legal precedents or answers to. So that's the motivation, right? We're responding very directly to the needs of our operators who want to have legal certainty and understand what the rules are when they go to the moon and cislunar space and then beyond. And I think that also starts to answer the question at the bottom of my slide, is this some kind of nefarious plot? I put that up there because there's been a lot of, let's say, overwrought reaction to the Artemis Accords in the press and on Twitter, space Twitter, for those of you who follow space Twitter. Some of that, I think, is simply because the fact that we're still in negotiations with our partners. So the Artemis Accords, the actual text, isn't something that's public. So understandably, people have only been able to react to what they've heard. But I do want to take this opportunity to say, the Artemis Accords isn't some kind of sneaky or attempt to expand American control to the moon, or change international space law or anything like that. I think as we dig into the specific provisions of the Accords, you'll see it really is focused on these operations, and it really is trying to answer operational needs with rules that, as Mike said very clearly, are very closely tied to the Outer Space Treaty. So let's go to the next page, the next slide. One question, as an international lawyer that I ask myself when policymakers come to me and say they want to do a thing, is I ask myself, well, what's the toolkit? What toolkit do I have available as a legal matter? What legal toolkit do I have to address these questions? And I know many of you on the Zoom call know all about the Outer Space Treaty and international space law, but I did want to put this up on the screen just so we're all starting from a little bit of a similar place. There's a series of international agreements negotiated in the middle of the 20th century that talk about what the rules are for countries that do things in outer space. The Outer Space Treaty from 1967 is the most prominent of those, and it really goes into some detail on how you should behave in outer space. However, it doesn't include a whole lot of specifics. It really reads something like a national constitution almost. It talks in terms of high-level principles, and with a few exceptions, really doesn't get into the details. So it provides general guidance, and of course you have to comply with it. This is a legal obligation for all parties, including the United States. But what it actually means to implement these obligations is something that has so far not been elaborated. So this is the toolkit, at least in my mind. These existing treaties are the toolkit we have to answer the questions. Let's go to the next slide. So in order to answer those questions, as Mike said, we came up with a number of principles, and you've already seen them on your screen in Mike's slideshow, so I won't spend too much time on them. But we came up with 10. It's a nice round number, and we think these are some of the most important principles that are going to be faced by operators as they go to the moon and cislunar space and beyond. Some of these we can focus on more, and perhaps in questions we can talk about them more in detail. But these are the most important ones, and virtually every one is a clear implementation, I would say, of a provision in the Outer Space Treaty or one of the other space treaties. So I want to spend just a couple minutes focusing on a couple of the more, let's say, more controversial or questions that have gotten more discussion on the internet and in press pieces in the last few weeks and months. So let's go to the next slide. So space resources. I like this picture just because I think it's cool. But of course, this isn't actually what people are talking about doing in outer space, certainly not in any kind of near or medium term. Right, what we're actually looking at in terms of the Artemis program is technology demonstration leading to the potential for in situ resource utilization, right? Not people in spacesuits scooping up what appear to be gold bars, I guess. So let's go to the next slide. So given that we're going to be looking to do in situ space resource utilization and technology demonstration, and that we want to be there with our partners, of course, the starting point to figure out what rules there are the Outer Space Treaty. And the Outer Space Treaty, I've put up quotes from Articles 1 and 2 on there, and I'm not going to read them. You can look them up yourself or read them on the screen. But basically, Articles 1 and 2 of the Outer Space Treaty are where we start when we talk about space resources. Article 1 talks about freedom to use and explore outer space. And then Article 2 includes a prohibition on national appropriation of outer space, which our longstanding understanding of that provision has been that it means you can't claim territory on the moon or some other celestial body or anywhere in outer space. You can't plant your flag and say, this is part of my home country, for example. So those are the tools that we have in existing law. So then as we move to the Artemis Accords, let's go to the next slide. All we're looking to do with the Artemis Accords, because this is an agreement amongst partners, is to create sort of a basic understanding that we can start from. Right? It's not going to go into any kind of great detail about space resources. It really is to create a common understanding of where we're starting from. And where we're starting from is the Outer Space Treaty. So really all we're looking for here is to set out a common understanding that you can use space resources. It's lawful, it's not prohibited, as long as you aren't trying to claim territory and as long as you aren't doing something else that would otherwise be prohibited under international law or domestic law. right? Just because you're doing it with space resources, of course, doesn't get you around any other obligations you might have. So that's it. That's all we're trying to do with space resources, is to articulate this common understanding, which, as I said, has been a long-held one from the United States, at least since the 1970s. So that's space resources. Let's go to the next slide. The other question I wanted to talk about here, because it's a little bit of a more complicated one, is deconfliction of activities. And deconfliction is a term I've stolen from my DoD colleagues who talk about deconflicting operations when you have multiple units or multiple actors doing something in close proximity to each other. And you don't want to step on each other's toes, right? It's as simple a concept as that. So let's go to the next slide. So for the Artemis Accords, right, what the heck is deconfliction? How do you do it in space? We once again look to the Outer Space Treaty and we say, what are the tools in our toolkit? And here we're in particular looking at Article 9 of the Outer Space Treaty, which includes a lot of stuff, and I'm not going to read it again, but there's two things in particular that the Outer Space Treaty includes that I think we can build on. One is this obligation that actors in outer space conduct your activities with due regard to the corresponding interests of all other parties. So that's one, this due regard obligation. And Article 9 also says that if you're going to do something that could potentially cause harmful interference, you should consult with others who might be interfered with or who might be interfering with you. So again, that's our toolkit that we're starting with the Outer Space Treaty. So let's go to the next slide. And what does that look like when we try to take it one baby step further and say, all right, how do we operationalize that on the moon or in cislunar space? It's pretty straightforward. You know, telling other people what you're doing in outer space, telling them where you're doing it, right? Geographically, either on the surface of the moon or in a particular orbit or something like that. Be public about whether there are safety or interference concerns that you might cause to others or that they might cause to you. And of course, a lot of this is going to vary by the nature of your operations. Some types of operations will be more susceptible to interference than others. And then if there's a problem, a potential confliction in terms of activities, you talk, coordinate, and you work it out. So I think you heard Mike talk about safety zones, and we do talk about that in the Artemis Accords. But when you boil it down, what does a safety zone mean? This is what it means, what you see on the screen. It's telling people what you're doing, telling them where you're doing it. It's not saying you can't ever come. It's saying, well, here's the concerns we have if we're going to be operating in proximity to each other. Let's talk about it before you, other operator, come near, and let's coordinate our operations. So that's really it. It's not some kind of territorial claim. It's not saying this is a keep out zone. It's really a coordination mechanism to ensure that we can all do our activities in outer space. So let's go to the next slide. So I'm also ending with a picture of people sitting around a table, just like Mike did, because I think that is the end thought of the Accords, is that the whole driving purpose of the Artemis Accords is to get those countries that will be working with us on the moon and cislunar space and on Mars to come together and have a common understanding of what are these basic rules that we all have to apply as we do things together. And as I think you'll see as we talk about this more, much of that boils down to conversation. It boils down to learning to live and work together in a place we've never lived and worked together before. And as I said at the beginning, this isn't some attempt to change space law. It's not some attempt to claim things for the United States. This is really an attempt to say, all right, we've got the toolkit in the Outer Space Treaty. Now we have real operational issues. It's an opportunity and it's exciting, but it does raise questions of how you implement those space law obligations. So we've tried to come together with our partners and say, all right, at an operational level, what does implementing those legal obligations look like? And a lot of times it's going to be talking, quite frankly. A lot of times it's going to be talking and coming up with flexible solutions. So I think I'll stop there. There's lots of other principles in the Artemis Accords we could talk about, and I look forward to your questions.
You can see what a technical expert I am. Gabriel, thank you very much. That was excellent and very informative for us all. So, ladies and gentlemen, we've now had two similar but also different perspectives from the US administration about the raison d'etre behind the Artemis Accords and some of the more details about the principles. So we're now going to move on and have Professor Jakhu, one of my dearest, oldest friends, Associate Professor from the Faculty of Law at McGill University, who will explore certain aspects of the principles, particularly in relation to the exploitation, exploration, and utilization of resources. Ram, the floor is yours for 15 minutes. Thank you.
Thank you very much, Stephen. Before I start my presentation, I would like to, as one of the hosts, express my gratitude for all the experts who joined us. Particularly, I will start actually with you, Stephen, and that's about half an hour or almost 1 o'clock in the morning in down under. And Mike, Gabriel, André, and Tommaso, wonderful to have all these experts with us. And of course, I welcome all the attendees of the seminar, webinar. Sorry. And here I am presenting my slides. Can everybody see these slides? I'm not sure of it here, but all right. So I will start as mentioning some key factors and what I want to talk about. It's really, I think here is the Artemis program. Its aim is really to find and use water and other critical sources needed for long-term exploration. That is mean in situ resource utilization. And from in situ resource utilization, the ultimate goal will be, or is for recovery and use of space resources. And then it's again, Mike and Gabriel mentioned, and it is an American program. I think we must admit that and recognize that. And also key partners are invited to play a key role in that. And that means it will be essentially carried out in compliance with and subject to American national laws, policies, and politics of the United States. But exploration and exploitation of space resources are space activities that must be carried out in compliance with or subject to international obligations of the United States and other partners, as Gabriel mentioned very, very clearly. And therefore, in my view, Artemis program and Artemis Accords should be seen and understood in a historical, broader American and global space governance and political context for recovery and use of space resources. When I will be using the word partner, that means states other than the US, NASA, and the space agencies. I will present my views mainly from the perspective of partners. So I will concentrate first, outline the opportunities these accords would provide to the partners and the challenges, some of them, and I will conclude with sort of way forward to that. So what are the opportunities? This is one thing we all recognize. World has population about, say, about 8 billion, 7.5 billion today. By the end of this century, it will be about 11.2 billion people. Exponentially increased population will need and consume resources exponentially. That means there's a search for, that's why there's a search for resources, not only Earth, but on the space, in space. Because these resources on Earth will be depleted, which is generally accepted, by the close of this century. So the depletion of natural resources on Earth is dictating and inspiring search for resources in outer space. But the preliminary investigations show promising prospects for recovery and use of resources of the moon and asteroids. So what we find, what we will be finding on the moon, this is a very good, chart prepared with Jet Propulsion Lab. It will be water, helium-3, and rare earth metals. And rare earth metals are vital for emerging technologies on Earth. Here is a very nice picture or the photographs created by U.S. Geological Society and NASA Lunar Panels Institute. It shows the map of the distribution and classification of the minerals deposits on the moon's surface. And then it, to me, eventually, after starting with the Artemis Accords, it will be possible to bring back to Earth the resources of substantial strategic and economic value worth trillions of dollars. However, the short-term goal is to facilitate in situ resource utilization for creating lunar habitats and aiding interplanetary missions. NASA, in my view, I'm fully convinced, NASA possesses considerable expertise, technology, economic resources to undertake and lead exploration of space, exploration for space resources. That means states are now have unique opportunity for international cooperation with NASA in the form of Artemis Accords, leverage their expertise in lunar exploration. However, there are challenges particularly which I will focus on, challenges for partners. But before we get into the challenges, I want to show it to you. It's sort of Artemis Accord in historical perspective, as I think the point has been made with respect to International Space Station, but we should not forget the first and extremely important cooperative arrangement which was put together by United States early in late 60s and 70s, what the Intelsat was initiated by the United States under an international treaty and open to all states for the benefit of all mankind. International organization was created with international personality, and it involved equitable financial investment with public-private partnership, sharing the benefits equitably, and it was run on like a business operation, very successful. The second is of IGA for International Space Station, again initiated by the United States under a multilateral treaty among the partners on the basis of genuine partnership, supplemented by bilateral agreements with NASA, but without permanent international organization. I know Mr. Farand will elaborate that point later on. And then we have it here, Artemis program, again initiated by United States to be carried on bilateral agreements between NASA and partners, but without multilateral treaty and without permanent international organization in that fashion. See, and then look at some issues. First, under U.S. law, and Gabriel has made the point very well, that under U.S. law, natural resources of the moon can be appropriated. And then U.S. does not view outer space as a global commons. U.S. has started implementing its understanding of Article 2 of the Outer Space Treaty through its national legislative administrative steps, and the latest what are the Artemis Accords. NASA is expected to follow and promote these binding directives and understanding of Article 2 of the United States government when negotiating and signing Artemis Accords with partners. Now, if a state is of the opinion that appropriation of natural resources is contrary to Article 2, it would need to carefully examine its position before signing an Artemis Accord. Otherwise, it might impliedly indicate its agreement with the US interpretation of the article. And that will apply to safety zones and also with respect to the status of outer space as a global common. And then US has recently rejected the Moon Agreement. By the way, I'm sure all of you may know that US had actively contributed to the adoption of this agreement, and US has decided to object to any attempt to treat the agreement as customary international law. The states that are party to the Moon Agreement, for example, Austria, Australia, Belgium, Netherlands, Saudi Arabia, among others, might need to examine the implication of their obligations under this agreement before joining the Artemis Accords, if invited. Under the Outer Space Treaty and the Liability Convention, a launching state is held internationally liable, jointly or severally, for damage caused by their space object. A state that plans to sign an Artemis Accord need to see if by doing so, it would acquire the status of a launching state for any space object launched for the purposes of the Artemis program. Now, there are a few other issues. Again, before becoming a partner, state need to envision and prepare for some financial and other consequences in case the Artemis program is canceled or significantly changed by United States for any other reason. One could be budgetary constraints, or US unilaterally withdraws from any Artemis Accords, or US imposes sanctions. Those are the eventualities, I will say kind of risk, which any country which wants to be a partner should envision and prepare and find out more about these things so that it remains a viable proposition for these countries later on, or they do not suffer in any significant manner. Now, it is envisioned that a significant amount of technical and strategically important data would be exchanged during the negotiations, as well as during the entire period of the operation of the Artemis Accords. NASA's commitment to the timely, full, and open sharing of scientific data may be hindered by US export control laws, including ITARs. And so I'm sure some of you, if not all of you, know that such laws are extensive and extraterritorial in nature, and the violations are punished very severely. These are some of the legal and policy risks or challenges of international cooperation with the US in the form of Artemis Accords. They are not, in my view, they are not imaginary or academic. They are real. And thus, they must be addressed carefully before signing the Artemis Accords. So to conclude, for prospective partners that plan to sign the accords with the NASA, there are several serious issues which need to be considered. I just try to highlight a few of them. If states or their space agencies can successfully meet these challenges, and in my view, Artemis Accords can provide excellent opportunities and significant benefits for the partners. States and their space agencies should carefully, thoroughly, and broadly examine the costs, risks, and challenges and benefits of cooperation with the NASA. And such accords should be, in my view, negotiated by a team of experts in technical field and also business people, as well as experts in international relations and law. With that, I finish my presentation. I'll be glad to answer any questions you may have. Thank you very much.
Thank you so much. Thank you for raising some interesting issues that clearly require greater thought and consideration, and we'll obviously seek some responses from our other speakers at the end during the Q&A. But thank you, Ram. Thank you very much. We now move on to another expert in the field, André Farand. André was the former head of program in the Legal Services Division of the European Space Agency. André was very much involved in the negotiations for the intergovernmental agreement that was referred to earlier for the International Space Station. And we welcome you, André. Thank you for joining us. The floor is yours for 15 minutes. Thank you.
Thank you. Yes, so I hope you hear me.
Yeah.
Yes, okay. So my task was to make the link between the International Space Station agreements and the Artemis Accords. And so there are 4 points I would like to raise. First, that the Artemis Accord, they were proposed like a publicly available presentation to NASA, to other space agencies on 15th May, and took the form of a listing of generally worded principles being a mix of pre-existing and widely accepted norms of international space law, but also additional norms tailored specifically for lunar exploration activities. And they were presented as a prerequisite for the conduct of lunar exploration cooperation with NASA. However, with no clear indication on the way forward for their bilateral formalization. Second point I would like to say is that NASA's proposal for Artemis Accords is significantly at variance with the usual prudent approach in the conduct of international relations among spacefaring nations, as evidenced in the negotiations of the ISS agreements. That's a point I would like to detail also. And finally, the ISS agreements or the underlying provisions and principles still constitute the mainstay for establishing between NASA and the other ISS cooperating agencies agreements governing their cooperation on different components of the NASA Artemis program. Now, they are, so since the ISS agreements being the intergovernmental agreement, the IGA, signed by 15 states, 11 of them being European, and 4 memorandum of understanding between NASA and each of the other cooperating agencies for Canada, Japan, Russia, and Europe. And they are quite different in nature. The ISS MOU, the ISS agreements, and the Artemis Accords are quite different in nature. And so the approach for their conclusion should be and will be different. In the ISS, IGA, and also in the MOUs, because MOUs often are considered international agreements. It's the case for Canada, that has, it's a derogation to its normal practice. It's also the case for Europe because ESA is an international organization. Then the ISS, IGA, and MOU are binding at as international agreements, and they generate rights and obligations for their signatories at international law. They have been developed over prolonged periods of negotiations. As you know, the 1988 IGA took 3 years to negotiate. 1998 IGA, the second IGA, took 4 years to negotiate, and mainly at the level of the Ministries of Foreign Affairs, also with the participation of the cooperating agencies that had a special role for the MOUs. So it was a long time in the making. And also they have been drafted with particular care among so to ensure not only that what the provisions are corresponding to what the partners want, but also that is compatible with the legal framework of each state signatory to these agreements. Now, the IGA also, we have to remember the IGA, the Intergovernmental Agreement, was subject to ratification by each signatory state. And that was a requirement to enter into force, and a number of states, and I mentioned 3 there, Canada, Germany, and France, incorporated the full text of the IGA in their respective internal legal orders. What does that mean? It means, for example, that if a court is seized with a case that goes against the IGA, something happening on outer space but related to the IGA, the court in one country can take jurisdiction over the case, which is the way of translating into national law the obligations of the IGA. Very important, a clear distinction was made between the topics falling under the purview of either the states, and the IGA outlines top-level principles applying to the cooperation for the International Space Station, and also the competence of the cooperating agency. That's why the 4 MOUs detail the actual ISS elements to be provided and how the cooperating agencies work among themselves. And also, the IGA preamble, we have to recall, already recalls and thus make them applicable to the cooperation on ISS, the 1967 Outer Space Treaty, and the other main UN-developed space conventions. So in other words, the ISS cooperation is conducted conducted completely in agreement with the UN conventions. The proposed Artemis Accords put forward topics related to the implementation and furtherance of concepts already contained or alluded to in the 1967 Outer Space Treaty. That was said before today. Now, executing bilateral Artemis Accord is presented as a prerequisite for any interested international space agencies to join NASA in the Artemis program. On that point, please remember that the Artemis program is the NASA program, and if other agencies will join in lunar exploration, it will be under their own programs. And for Europe, that program is called E3P, the European Exploration Envelope Program. So when presenting, NASA presenting a proposal for Artemis program, Artemis Accords, it's like saying we will integrate you partners, your activities in our own NASA program, which will not be the case and should not be the case. Now, interesting to note that once the space agencies will have signed Artemis Accords, they will have to take steps at internal law to make sure that the commitments taken in the Artemis Accords are translated at national law level. So that's an important point. The other one is the invitation is not limited to the ISS partnership. So the question can be asked, will the conclusion of Artemis Accords be combined with elements of quid pro quo in terms of agreed role or space exploration activities? Mike Gold just said that there will be an annex spelling out the different activities to be conducted with, for example, the UAE Space Agency. So that is already an answer to this question. Also, there is clearly a sense of urgency on NASA's side, and it is difficult to reconcile the conclusion or the timing for the conclusion of the Artemis Accords with the inherent lag time of treaty-making practice, as we have seen when we negotiated the ISS agreement in the 80s and 90s. Now, also, the lines, when you read the presentation on the Artemis Accords, the line between the respective state level and agency level responsibilities have been significantly blurred. And this is a very sensitive issue, particularly for Europe. Now, the denomination Artemis Accord used by NASA calls for the following remarks. The Artemis program is the NASA program, and it contains, when you read the internet pages on that, three main elements: the Space Launch System rocket, the Orion capsule, and the Lunar Orbiting Gateway Space Station, the Gateway. Then the use of the word accords would normally refer to a set of commitments from states contained in an international agreement concluded in accordance with applicable practices of the states concerned, generating rights and obligations at international law. But in the case of Artemis Accord, there are signs that a formal binding international agreement is not what the US administration is looking for. First, the proposal is submitted by NASA, which is not an actor at international law, to other space agencies, except for Europe, which are not actors of international law. Also, there's a perceived sense of urgency because of the expected landing of humans on the moon by end 2024. So the treaty route for finalizing the accord is not practical. And this, I think, Mike Gold has said that publicly before. And the executive branch of the US government regularly makes non-legal political agreements with foreign entities, such agreements carrying significant moral and political weight for the parties. And when you look at the word accords on internet, you see the Helsinki Accords of 1975, which were not legally binding at international law, but they were clearly significant in terms of political weight and moral weight also. Then the ISS agreement today are very important. They are the mainstay of the Artemis program related cooperation in at least two elements. And I'm talking about the Orion capsule, which is a key component of the program, as we have said, and there will be 3 flights up to 2024 to get a woman and another crew member on the moon. This Orion capsule is equipped with the European Service Module, ESM, which is ESA's contribution to the spacecraft, will provide electricity, water, oxygen, and nitrogen, and is designed to maintain the spacecraft at the right temperature and on course. So that's the ESM. Now, the ESA-developed ESM-1 and additional ESMs are contributed pursuant to dedicated implementing arrangements concluded under the NASA ESA ISS MOU. So it's really linked very closely to the ISS agreements. And also this is a barter arrangements enabling ESA to compensate the partnership for the European partners' share of ISS common operation costs, accruing over an agreed period. And that is really encouraged by the ISS agreements. So that's for the Orion capsule. In last March, only a few months ago, the Gateway, once referred to as the linchpin of the Artemis program, has been taken off the critical path for NASA's return to the moon in 2024 for a number of reasons, including budget-related ones. And so the development period for the Gateway will be stretched considerably and its content modified. And starting at the end of last year, November 2019, NASA and each of the other ISS partners were progressing in the negotiation of a series of bilateral MOUs. And bilateral MOUs is also the model that was used for the space station between NASA and each of the agencies concerned. So these MOUs on Gateway sketch out the respective roles and responsibility of each partners in this Gateway endeavor. And the objective at the time, at the end of last year, it was said we need to conclude this MOU negotiation by the end of the first semester 2020. NASA stated at the time that the objective was to extend, through the reference in the Gateway MOUs, the application of the relevant ISS IGA provision to the execution of the Gateway cooperation. And so what happened after that? Now, what we see when we talk about extending IGA provisions to the Gateway MOU, it's a bit of a difficult matter, in particular for the 11 signatory states forming the European partner, because there is a strict limitation of competence between the member states of the European Space Agency and the 11 states member of the organization that have signed the IGA. So it's difficult to in a MOU signed at agency level, to say to the states, you have new responsibilities, new commitments under an international agreement. The link is not obvious. Now, in December 2019, the European partner states revitalized their IGA Coordinating Committee, IGACC, which is hosted at ESA, and have held different meetings to examine different approaches to accommodate the application of the IGA to the Gateway. But good news, on the 24th of June, ESA approved the draft MOU concerning cooperation on the civil lunar Gateway. So the text has been finalized and approved. But then you have to look at other news, which is that the IGA will have, the IGACC will have the challenging task of establishing an appropriate intergovernmental legally binding framework for multilateral cooperation beyond Earth orbit in good time before the launch of ESA-provided Gateway elements. So in other words, the work, it seems, remains to be done at IGA level to make sure that the principles of the IGA would extend formally to Gateway cooperation.
Andre, could I just ask you to move towards conclusion?
Okay, I'm in the conclusion. The conclusion is here. The difficulty will be to have the detailed wording accepted multilaterally. So possibly it's bilateral instruments, but they have to be finalized multilaterally if you want to have the same kind of wording for everyone. The content of the accords fall within the competence of states. So you have to make sure that you have the proper legal link with the states and not only space agencies. And also the quid pro quo, and that was said, it's not only the opportunity to carry cooperation with NASA, but it's also to get actual activities of cooperation to be described in the Artemis Accords. That was my conclusion. Thank you.
Thank you so much, Andre. And again, my apologies for interrupting, but as I said, the idea is to leave lots of time for questions. But thank you so much for your presentation and for bringing in that linkage and comparison between the negotiations and agreements of the ISS and the negotiations here. We appreciate it very much. So our final speaker is my dear friend Tommaso Sgobba, who is the Executive Director of the International Association for the Advancement of Space Safety, one of the co-organizers of this great event. Tommaso, it's a pleasure. Thank you for organizing this together with RAM, and you can see what a great response we've had with so much interest. Tommaso, the floor is yours for 15 minutes. Thank you.
Thank you very much, Stephen. I would like to ask Kiran to show my presentation, and I will call the slides one after the other. First of all, I am the first non-legal expert talking during this webinar, so I will probably bring a little bit of a different perspective. Next slide. Next, Kiran. So first of all, I would like to make the point that except for space resources principle and deconfliction of activities principle in the Artemis Accords, all the principles over there are truly reiteration. I would not say implementation. There is nothing truly about implementing, but a reiteration of existing principle well established by United Nations treaties and by guidelines like the one on space debris mitigation. In all cases, so including the issue of space resources and deconfliction of activities, what I see as potentially contentious is not the principle in itself, but the possible implementation for which there is truly no indication what this will be, except by reading presidential directives which has been issued in the last period. I will touch upon two principles in the Artemis Accord. One is related to space debris and spacecraft disposal, and the other is about interoperability and emergency assistance. Please, next one. Again, next. Yes. Now, space debris mitigation. Basically, what this principle says is that the partners into the Artemis Accord shall commit to the effective compliance with United Nations space debris mitigation guidelines through policies and national laws and regulations that implement best practices. Next slide. Just to recall the content of the United Nations space debris mitigation guidelines, there were basically 7 key guidelines: limit debris released during a nominal operation, minimize the potential for breakups during operational phases, limit the probability of accidental collision in orbit, avoid intentional distraction and other harmful interferences, activities, and minimize the potential for post-mission breakups resulting from stored energy, and finally, to limit the long-term presence of spacecraft and launch vehicles in low Earth orbit and in geostationary orbit. So under this principle, these guidelines, United Nations guidelines, you see that there is everything that deals with space debris, and there is also basically the issue of space traffic management. So this is a big topic. What a partner would, let's say, commit to when signing the Artemis Accords would probably be mainly in relation to avoid making anti-satellites tests. That is one of the few things that truly may come directly as a result of signing the accords. But for all the rest, you need implementation. And the implementation which have been up to now, let's say, attempted by, let's say, the international parties, have to a certain extent failed, as we well know, to control the proliferation of space debris. Next one. And the problem is that when issuing standards, not all the standards have truly the same value and impact. There are policy standards and there are technical standards. To make an example, a limit about the pollution from in water, drinkable water. Perhaps a few people know that on the space station, the International Space Station, there are two drinkable waters, one for US and the other for the Russians, because the two parties were unable to find an agreement about the level of contaminants that should be allowed inside the water and about the type of biocide to be used into it. This means that when you have a safety-related issue, in many cases, the settlement of that issue is not only a technical matter, but is also a matter of consideration about, let's say, economy, risk, acceptable risk by the population, and so on. This is the meaning of policy standard. Instead, when we talk about a technical standard, could be a testing methods and things like this. In my view, next slide, the failure up to now of the space debris mitigation internationally has been the illusion of allowing an international body like ISO to deal with both political as well as technical standards. And basically, when they have issued political standard, which is the debris mitigation standard, the ISO 24113, they have done this within a group of people, panels, working group that had purely a technical, let's say, responsibility and were not representing truly a commitment from the governments. The message is that we will continue to have problems with the implementation of space debris mitigation guidelines by UN, as long as there will be no forum at international level, political forum, legal and political forum to deal with this matter. As long as this matter will be treated as a purely technical one, we will fail to resolve the problem. Next slide. Again, let's go to interoperability and emergency assistance. Interoperability and emergency assistance are two principles very much linked together into the word of the Artemis Accords, because they refer to the fact that to be able, in case of an emergency, for a country to help another country, there must be a way for the system to interoperate for vehicle, for spacesuits, for habitat, for modules, for robots, to exchange data, to get power supplied by different systems. This is interoperability. Next slide. The problem is that in the Artemis Accords, interoperability is apparently approached only from a technical point of view, the technical interoperability. So what kind of interfaces must be there such that two systems will be able to communicate, to operate together, etc. But there are other types of interoperability which are essential in case of emergency, like legal interoperability and semantic interoperability. What does it mean, legal interoperability? Imagine to have an emergency on the moon. There is an astronaut which is injured, and then one of the partners can help, assist in this medical emergency. He needs to get data, medical data. So if you have communication lines, I mean, if you have a possibility of talking between the two moon bases, the fact that you have this interoperability, technical interoperability, doesn't mean that you have also a legal interoperability. So to have this, you must have reached agreement about exchanging of certain type of data. Semantic interoperability is a further, let's say, item which deals with the language that you use for emergencies, which should be able to cross different, let's say, system and still maintain the significance. Next slide. Next slide. Next slide, please. Yes, again, further. Let's go to the current status. In the frame of the International Space Program, there has been already an effort by the parties to develop a standard for interoperability, but these are only technical standards which are aimed to become perhaps in the future also open standard. Next one. Next one. Again, Kiran? Yes. Let's go to emergency assistance. Here, there is the key point, I would say, of my presentation, because in the Artemis Accord, it is stated that, the partners will do whatever is reasonable to do in case of emergency. But this is enough as long as we are talking about emergencies on Earth. But when you are on the moon, if you have not planned, prepared, and set up the necessary capabilities and infrastructure, any kind of emergency assistance will be basically impossible. Let's see what is written into the accord, not the accord, into the Outer Space Treaty and into the astronaut rescue agreement. Next slide. Here we see that in the emergency, with reference to emergency assistance, in the Outer Space Treaty, there is Article 12 that basically says that all station, installation, equipment, and space vehicle shall be open to representatives from other states parties. And secondly, that the way state parties operate shall be guided by principle of cooperation and mutual assistance. Next slide. Emergency assistance, according to the astronaut rescue agreement, goes in even further commitment, which are the following. It states under Article 10 that state parties shall offer shelter. And then under Article 12, that state parties may use, in case of life-threatening emergency, equipment, vehicles, installations, facilities, or supplies of other state parties. Now, this is not just a reasonable commitment. This is an obligation to make possible the one partner to have access to the other partner facilities. And this is something that truly can be realized only through an international program. So if tomorrow today, tomorrow, and in the next months and year, NASA and the other spacefaring countries willing to go to the moon will not set up truly a program for emergency assistance will just not be possible as such. Next one.
Tommaso, if I could ask you to move to conclusion, please. Thank you.
Yes, yes. This slide shows basically the kind of vehicles and the kind of technical, let's say, intricacies related to the access, egress on the moon, because there are dust regolates that represent an hazard entering and leaving an habitat module required a number of let's say specific dedicated equipment, and the coordination of different equipment to be interoperable is a big issue. Next slide. Next slide. Yes. This slide shows that what we are talking about today, emergency assistance, as a program, has been already done in the past. In 1975, there was the Apollo-Soyuz test project. That was meant to be a testing of the capability for rendezvous and docking between two systems, one from US and the other from Soviet Union, to come one to the assistance of the other. And during this test, there was also, next slide, there was also a close call, the possibility for an accident, which also, you know, drives the need to assess also liabilities related to emergency assistance. Now, in conclusion of all this talking is that the implementation of Artemis Accord could be reasonably achieved in the next several years only if there is an international program for standards, which is first of all a program between international countries. So not between standardization bodies with the purpose of defining the top level principle for such implementation. Thank you very much.
Tommaso, thank you so much for your insights and to raise important issues about, for example, safety of human beings and standards. That completes the formal part. So thankfully now we have about 30 minutes for questions. We've already received quite a number, and I'll move on to them straight away. But it seemed to me that there was a theme emerging from, if you like, the three latter speakers in response to Gabriel and Mike. And that seems to be about seeing where this process might sit within a broader, if you like, multilateral process, within a broader, as Tommaso said, standards process, universal standards. So perhaps I could ask Gabriel or Mike first to respond to say where they see the Artemis Accords, which clearly there will be a discrete number of partners, a discrete number of bilateral arrangements, and there will be many other countries interested in similar activities. Where do you see the Artemis Accords fitting in as a part of a broader picture, perhaps, in the multilateral process? And then Ram, if you could back onto that to say, having considered that, does the Artemis Accord, in what way will it, or can it, or should it contribute to perhaps the ongoing development of the international legal framework? So Mike or Gabriel, or both of you, please, and then Ram, and then, of course, any other speaker who would like to. Thank you.
Yeah, really appreciate it, Steve. The Accords are intended to spur a multilateral conversation. As you just heard, we are not only adhering to the Outer Space Treaty, but we're really following its strategy relative to listing out principles. Now, we will operationalize those principles relative to the actual activities. So, for example, if we have a rover, it would respect a heritage site. It would not harmfully interfere with other activities. But ultimately, as you look at, for example, what is a heritage site? That's a multilateral conversation, and we look forward to engaging with COPUOS or other international forums to define that process. So the accords are intended to inform that. I also just have to take issue with the statement that was made that the process of the accords were at variance with how traditionally these negotiations occur. Because if that was the case, and I'm losing a lot of sleep and waking up early and going to sleep late over nothing, that not only have we followed a path very similar to what was done with the IGA, but even the very individuals who negotiated the IGA at NASA are engaged. Now, you're going to have a very different process with something like the Accords that are a series of principles versus an operational activity with an International Space Station that's multilateral versus these bilateral principles. But the process is the same in terms of going to countries, getting feedback, iterating, going back again, new document, et cetera. And I assure you that NASA is proceeding on a very cautious, prudent, and respectful path to gain the feedback from the international community, which, as I said, was extremely valuable. So I don't know how we can call something a quid pro quo when we're working hand in hand to develop principles that not only ourselves, but the partners agree with just as much as we do. I also have to take issue with the contention that this is NASA going to other space agencies, because that's just factually inaccurate. That we work in tandem with the Department of State. That's why Gabriel's here, and the actual negotiations or the submissions occur from our Department of State to the ministers of the other countries. And we would certainly be more than happy to accept binding agreements, and we have solicited such. So again, I think that's just not true. And I understand the frustration that we can't be completely transparent relative to the process or give you the text that would detail that, but that is in keeping with traditional negotiations, that the current text of the accords are going to change. Again, they're going to be improved by the feedback we get from the international partners and international community, which is why we can't reveal where we're at every step of the way, because it's going to change so much. And we believe that demonstrates our respect for the internationals and the fact that we're following a traditional process. Gabriel, can I turn it over to you for an additional comment or two?
Sure, Mike. And of course, I second everything Mike said in terms of the process, and don't have much to add there. Just in terms of the specifics about how does this interact with the more traditional international and multilateral system. I think many of you all know until this year, I spend every spring at the legal subcommittee at COPUOS talking about those things. And of course, the United States is and will continue to be highly engaged in the formal UN multilateral process, as well as a number of other collaborative processes. We've seen the Hague Space Resources Working Group, and we've seen a whole variety of other sort of parallel or side processes. And just in terms of the substance of the accords, I think there's sort of two things to keep in mind. One is that where the international community and industry has developed more fully articulated standards at a technical level, we draw on those in the accords. So for example, orbital debris and spacecraft disposal. The principles in there are not things we've made up out of whole cloth. They're things that build almost entirely, frankly, on the multilateral system. So, again, as Mike said, we can't share the text right now because it's under negotiation. But I think if any of you could see it, it wouldn't be surprising. It would be things that people who've been involved in those multilateral conversations would see as very familiar, and including some direct cross-references, quite frankly. Other parts of the accords are taken, if not verbatim, but almost verbatim from discussions we had at the Hague Space Resources Working Group. And then there's other topics, like Mike said, for example, human heritage, where what we're really trying to do is start a conversation, set out some very broad principles and rules, and then recognize that means the next step, once the accords are in place, is that we'll then have to have, as I said at the beginning, more consultations, more conversations, not only with our partners, but with the broader international community for what that really means. So it's absolutely not designed to shut down conversation or avoid more traditional multilateral processes. as I said, it's trying to meet the needs of our operators because they really are going to do things. So we don't have time to sort of wait decades to have an internationally negotiated or multilaterally negotiated accords, because we have to provide guidance to our operators. But that doesn't mean that the conversation ends. It means that this is the floor. This is a baby step beyond the Outer Space Treaty, and that we will look to our partners as well as the broader community to flesh out even more what these things mean. And I really think, you know, once the accords are a little bit more public, once we're able to talk in even more detail about the specifics, I really don't think anyone's going to see anything in there that surprises them. We really have done our best to draw from the best of what's been coming out of the multilateral and international and academic processes all around the world.
I can just step in before he comes in. I was wondering, I know Stephen asked me to respond to the question that he raised. So my thoughts are, first of all, I want to really express my thanks both to Mike and Gabriel providing that information, because that kind of information is generally not available. People like me who are researchers, we just have to rely on the media, and the media does a pretty good job, but does not provide the things you're looking for. I think that explanation is very good, and I'm, you know, so thankful to that. I think when we look at, if I can say that, there's an effort to have a multilateral understanding, a multilateral. Stephen, I'm sorry, I just started.
No,
I thought you asked me to continue.
I disappeared into the ether, and I don't know. So
right,
I'm
okay.
I'm very happy to be back.
All right.
Please
Anyway,
continue.
so I'm just continuing to respond to your question. Okay. I think it's in that context, it's good to see what Michael said, a kind of document containing all the broad principles which will be common to everybody. And that I think is too good to me. So if I can say that, to me, that is, you're talking about multilateralism, a multilateral document, but you're negotiating bilaterally. You know, so there has to be some kind of multilateral forum which the countries can look at those principles to do that. So, or there is an assumption that whatever principle you have put together, everybody will say exactly what you want to say. I think that, to me, looks a bit difficult. So to have a formal document, I think negotiation has to be somewhat formal, because that is required by different governments. And then you can't have bottom-up approach. You have to have a top-down approach, that you have a kind, maybe a formal MOU or kind of a document agreed multilaterally, and then look at what needs to be done in the annexes, things like that. So there has to be a little bit more. So simply relying on bilateral efforts may not be sufficient. Now, I'm not saying bilateral efforts are useless. I think it's very important. So you are gauging the waters, looking at different things. I think it's that. But the step next should be some kind of multilateral forum with the people who have, the countries who have showed interest and expressed their views on that. So this is where I stop.
Thank you, Ram. My apologies, everybody, but you don't need me to continue this discussion. André, I'll come to you in a minute, if I could, to respond to some of the comments of Mike. But some of the questions, and this is where I'd like to bring Tommaso in as well. Some of the questions have revolved around the need to get not just feedback from partner states and prospective partner states, but from civil society and industry. And I think Tommaso made it clear that we need to understand, you know, a whole range of inputs, not just those that states, but perhaps other standards. So firstly, Mike, could I put it to you to explain, will there be a way that civil society can respond? How will industry respond? How will industry be involved in the shaping of the accords prior to them being finalized? Do they have a role at all? Thank you, Mike.
Yeah, absolutely, Steve, and it's a great question. The accords are ultimately and primarily a government-to-government agreement, but we are excited about the positive precedent, and all of us as attorneys can appreciate the importance of precedent that the Accords will set in some areas for the private sector, such as deconfliction of activities, such as space resources. Now, there are certainly several aspects to the Accords that we would not want to force on the private sector. The full and free open scientific data, for example, would probably run counter to private sector interests and proprietary needs. So I want to make clear that while there are areas where we're establishing precedents, there are many aspects that should not be applied to the private sector. Relative to how we will gain that input, each country is different. Here in the United States, we have what are called Federal Advisory Committees, FACAs, which include membership from a broad array of industry, think tanks, academia. I myself, before I was with NASA, was the chair of the NASA Advisory Council's Regulatory Policy Committee, where we had companies ranging from Boeing and Lockheed to SpaceX and Blue Origin coming together to provide advice, as well as professors from GW University, et cetera. So via that FACA process, we are able to get input from civil society, from industry, not only for the Artemis Accords, but for all the other activities that we conduct. As we have discussion with our international partners, we will ask them to do the same, to make sure that what they do with the Accords, and frankly, the rest of the activities, are informed by what's good for industry, what's good for civil society. What I hate is when I see conflicts between government and the private sector, or human exploration and science. We're all stronger when we work together and we all bring important points of view. And rest assured, as someone who was with the private sector 7 months ago, that their opinions will be welcome. They'll have a seat at the table, and we'll be using the FACA process to do so. And just to end, that's why I was really proud to be part of the Hague International Space Resources Working Group. I think it's important that we recognize the evolutionary role of commercial, and that our institutions need to change, that we need to have these groups where the private sector can be a part of it. And again, that's how we use FACAs, Federal Advisory Committees, here in the US.
Thanks, Mike. Tommaso, did you want to add anything about how industry and standards beyond states should be brought into this process, having listened to Mike's response there?
Yes, perhaps I would like to say one word, which is China, okay? Because China is probably a possible partner for the Artemis Accords, because if there is a country with the need to discuss this kind of accords, deconfliction of activities, etc., this is China. So the point is how it's possible to have truly a partnership according to the Artemis Accords with a country that, has a number of limitations established by the US Congress that cannot be overcome in terms of exchange of data and so on. I was mentioning before emergency assistance. There is an obligation under the astronaut rescue agreement to shelter or to offer shelter to those that are in danger, for example, on the moon. So what will happen if Chinese say, okay, let's prepare for the day in which we would need to get sheltered by you, or you would need to be sheltered by us? So this is where I believe the Artemis Accord truly will be challenged, because accords between traditional partners or even with new partners like UAE, cannot be so different from what has been done for 20 years and more than 20 years for the space station. So the challenge is with those that will be new, outside, powerful, having very large programs. This is the challenge.
Thank you, Tommaso. André, could I just bring you in your negotiations on the ISS? You dealt, for example, with Russia, and we've had some response early on after the accords were released and after the executive order from Russia that perhaps wasn't wasn't very enthusiastically positive. How do you, given your experience in negotiating with Russia, how do you see them perhaps playing a role here? And obviously, are they prospective for Mike and Gabriel? How do you pick? I mean, what are the criteria to find out what prospective partners are? And of course, China and Russia have their own ambitions along with other countries. How might that fit in? So first André, and then Mike and or Gabriel to respond.
Yeah, about Russia, the first reaction you read in the newspaper about this proposal for Artemis Accords was a bit harsh. But what we have seen, well, IGA and IS and MOU negotiations were truly multilateral. However, there always be side deals between the United States and Russia because they are, and it's in the agreement, the ISS, they are the founders of the cooperation. I mean, and the rest, Japan and Europe provides, let's say, equipment to increase the use of the station. But the main actors are Russia and the US, and we see it still. And so I'm sure that although the first reaction was a bit harsh, there will be discussion, maybe at bilateral level between the United States and Russia, that will smooth out the environment and will get there, because then it will be truly the partnership that will act as we have done in the past.
Thank you, André. Gabriel, given that you deal on a regular basis with both of those countries and all of the others, is there something that you could add as to the potentiality for those two countries to, I'm not aware whether they're already being spoken to as potential partners, but maybe we could get a feel for that?
I'll let Mike handle this one.
Okay, sorry, Gabriel.
Yeah.
Mike, sorry.
So, let me say, there was a Reuters article where there was questions posed to the Chinese as to what they thought of the Artemis Accords, and their response was neutral to positive, that they look forward to engaging in discussions relative to lunar development. I think that was a very pragmatic response. I appreciate it that, they were being patient and didn't want to jump to conclusions. And I want to say that the Chinese, at least via a leading law professor, Steve, someone you and I know quite well, were a very constructive participant in the Hague International Space Resources Working Group. So I'm very optimistic that China will embrace what we're trying to do here. And again, if you look at who we were looking for the Artemis Accords, there was really two criteria. One, that we're going to partner with under the Artemis program. As Gabriel mentioned, this is not academic or theoretical. These are operations that are going to take place in the very near future. So obviously we need to focus on those countries. And then two, that there are shared values. That being said, we are trying to craft the accords in such a manner that any responsible space actor who is a signatory to the Outer Space Treaty could become a part of them. So there shouldn't be anything in the accords that China shouldn't agree to. Now, there are a few things that we haven't seen them comply with fully, such as the public release of scientific data. We would like to see China move in that direction. And again, that's the precedent that we're seeing with the accords. But we were optimistic about the response that we have received from China. And again, are crafting the accords in such a fashion that we don't believe that there's anything here that they shouldn't object to or comply with. Relative to Russia, while there was a initial harsh reaction, candidly, if I was in the Russian spot reading the press, that was coming out, which was inaccurate, I might have had a similar reaction. However, by May 15th, when we were actually able to roll out the accords, we posted the summary, talked about the principles. You'll note that there was a TASS article featuring very positive comments from my counterpart at Roscosmos, Sergei Salveyev, where he really welcomed this opportunity, was pleased to see that we were proceeding on a basis that was grounded in the Outer Space Treaty, and look forward to having conversations on the accords. So once people find out what we're trying to do, even in China and Russia, they really come around and appreciate both the substance of what we're trying to do and the process that we're trying to do with it. And that's why I would ask you all you know, unfortunately, these kinds of international negotiations don't lend themselves to being transparent initially because we can't show you the text as we develop it. So please, you know, before anyone criticizes, you know, take a moment, you know, think about what that process is, particularly for all of you who have gone through it, and then wait to see what the actual text is, because as Gabriel said, I think you're going to like what you're going to see. Gabriel, is there anything you want to add to that?
Gabriel?
No, I don't think so, except that I'll use that as a jumping off point to respond to another question that I think a couple people have sent me direct messages on Zoom asking about the Moon Agreement. And I think the quick answer is that it's the same answer. As Mike said, we've tried to craft the Accords in a way that's so closely tied to the Outer Space Treaty, that's so closely tied to real operational needs, that we see this as an open tent, right? That any country, whether it's China or Russia or a country that's a party to the Moon Agreement, if they share our commitment to responsible behavior in space, and they anticipate the need to answer some of these questions as a practical matter that are addressed in the Accords, then we don't see any reason from our perspective why they couldn't sign up to the Accords and why they wouldn't sign up to the Accords. Of course, that's up to individual countries, but it's an open tent. We're not trying to shut anyone out, whether it's China, Russia, or parties to the Moon Agreement. So it's sort of the same answer for both of those questions.
Thank you, Gabriel. Quite a few questions have come through. Maybe I'll put this one back to you. You made the comment about the idea here is not to try to change the law. And a number of comments, 5 or 6 questions that have come to me are from people who perhaps are a bit more skeptical about that and saying, for example, there are assumptions that from what we know from the principles, assumptions have been made. A lot of that discussion around safety zones, for example, the notion of safety zones, assumptions that perhaps begin to look and smell and feel and taste like they might be beyond the accepted principles that we operate under. You know, is it really possible to say that the idea is not to change the law, particularly if you're trying, in a sense, to set a new set of understandings amongst, as you say, responsible behavior in space or whatever? Is there a risk that these principles will, in fact, notwithstanding the best intentions, actually find themselves challenging the existing principles that we have?
I hope not. I mean, of course, it's obviously possible for, say, a bad actor to twist anything. That's certainly not our intention. And I'll tell a little story, I guess. And usually I don't like it when people tell stories on things like this, but I think it helps understand what we're trying to do here. You know, Mike and I, along with a complete U.S. government negotiating team, we've spent a lot of time in the past year or so traveling around the world negotiating gateway agreements relating to the construction and operation of the gateway. And you heard a little bit about that in Andre's just remarks at the beginning. And as we've had those conversations, right, the gateway conversations are very closely tied to building and operating a thing, right? A very technical thing that you build this and we'll build that and we'll plug it together and it'll work in these kinds of ways. So as we've had those conversations with our partners over and over again, the question has come up, all right, what next? What after gateway? What about when we go to the surface of the moon? Because these rules just don't make sense. The gateway rules and the IGA rules are about operating stations in orbit. They are very operational in terms of sort of the technical pieces of plugging those Lego pieces together in space. We kept getting this question, and we were walking across another country's capital, going back to the hotel, and we realized that both NASA and the Department of State were thinking about this next step. We were thinking, if an operator came to us and said, how close can we get, for example, if we're going to talk about safety zones, how close can we get to, say, a Canadian rover? Or how close could we get to a Chinese moon base? And the reality is that we didn't have an answer to those questions. So to go back to my initial remarks, we have to come up with an answer. We're lawyers and we're policymakers, and we need to give our operators answers to these questions. So we look to the Outer Space Treaty, and we see what the rules are, and we see that they're very broad. So then we say, okay, what do the broad rules mean in practice? And with regards to deconfliction, since that's the example you gave, we started putting pen to paper to say, what are some criteria you would want to look at if you were going to conduct close proximity operations, say on the surface of the moon? And those criteria would be sort of the things I mentioned earlier. They would be things like, well, what's the nature of the activity? How many people are there? Do they have volatiles in a tank? You know, some technical stuff. What are the safety concerns? What radio frequencies are they using? And, you know, what's the geographic scope of those operations? And then we said, well, okay, you're going to want to figure those facts out. You figure the factual pattern out. And then before you go in there, before you do anything, you talk with the other actor and figure out what would be problematic from their perspective. What do you need to do your operations? So that's the safety zone, right? Suppose we call it a safety zone because it's a shorthand, but really what it is it's an area in which you need to do consultations so you don't infringe on each other's activities. Obviously, could that be abused? Yeah, most legal rules can be abused, but that's why the consultative process, the cooperative process, is also important. And it's why, you know, once you, for example, to continue the example of safety zones, once a country, say, announces that they feel like they need a zone of safety around their operations, that's not the end of the story. If another country, for example, or another actor thinks that's unreasonable, then they call them up and talk about it, and they work those problems out. Right? This very much isn't a territorial claim where you could say, you know, I put a fence around my operation, you simply can't come in, and that's the end of the story. No one's saying that. You know, once you're able to see the words, and I hope you're hearing us say, that's just not what we're trying to do, because we realize that really could be abused. The same with the heritage protection, right? So we really want to create a set of criteria that will then facilitate a conversation. And it's that conversation then that really puts us into implementation, and that's what prevents the abuse. I think is the constant iterative back and forth between all the actors in space.
Thank you, Gabriel.
Steve, can I add very quickly?
Oh yes,
to
Mike.
that
yeah.
You know, ultimately it's resolved at a multilateral level. That, as Gabriel described, the safety zone is two things. Notification in terms of where you're operating, what you're doing, and then coordination to avoid harmful interference. If there's any other way to meet our obligation to avoid harmful interference underneath the Outer Space Treaty, we'd love to hear it. And ultimately, as Gabriel mentions, whether it's safety zones or whether it's heritage sites, there's going to need to be a lot more detail. We will bring our experience from us and our partners via the bilateral Artemis Accords agreements and our operations as to how we respected these principles. And we hope that will spur an international conversation in groups like COPUOS, in forums like The Hague, to come to a multilateral understanding that can have more details. Again, we are trying to support multilateral conversations where we can come to a global agreement on these important topics, while ensuring that we have peaceful, transparent, and safe operations for what's going to occur in the near future underneath the Artemis program.
Thanks, Mike. Thank you very much. I fear we've come to the end of our time, but what I'd like to do is give each of our 5 speakers in reverse order just 1 or 2 minutes, literally, for final reflections given on everything we've heard, and then sadly we'll have to wrap it up. So Tommaso, yes, could I ask you to lead off?
Yes, I would try to conclude in this way. If the recipe for the future is debate in COPUOS, we are already at a dead end, okay? Because COPUOS is not an action body, it's a debate body. We need an action inside a standardization group at policy level. This is my statement.
Thank you, Tommaso. Thank you. André, you're on. Yeah.
Unmute. Yeah. So no, what I've heard in the last few minutes is that something what I thought before, because when we had ISS negotiations for 7 years, so 3 years plus 4 years, we, at least on the European side, didn't associate for formal consultation to private sector operators or players. And this is done normally in all international agreements, for example, for air transport, where the airlines and others are consulted and very closely consulted. Now we need to get to a point, we see with all that, where the space players, the operators and others, are associated with the process of negotiating international agreements. And that's the effort we have to do. And Tommaso in particular, when he spoke about how do you implement all these principles that you will put on paper, well, we need to have the real players on board through very close consultation.
Thank you so much, André. Ram.
My comments are very much similar to what André said, that this is a very important step which NASA has taken. I think bilateralism is good, consultation, find out what he's doing and that kind of thing. To be successful, it has to be more or less formalized at multilateral level, and also with the I would say legal documents. So my personal recommendation will be to go along or something similar to IGA for International Space Station, with of course with the modification, getting more private companies involved in that, something more flexible and more countries involved in. I think then it will be highly successful. Just keeping bilateral negotiation all the time, and I think it will not be that that conducive to the final project. Now, of course, NASA is in the lead, and this is my suggestion to NASA. Multilateralism is the way to go to the maximum possible extent.
Thank you, Ram. Thank you very much. Gabriel, would you like to make any final reflections?
I think I'll just point people to the NASA website. I'm sure many people who are listening to this have already seen it and maybe have it up on your screen right now. But if you haven't, I strongly suggest that people pop into Google, and type in NASA Artemis Accords. There's a website there, and it talks about the principles. And of course, it's not the text. Here's the text. Sorry, we can't share it. But it talks about the principles that are in the Artemis Accords. And I really challenge anyone who's skeptical about the Artemis Accords or who's concerned about the motivation or where this will go. I really challenge you to find things in there that you have an actual concern with. Because I think once you sort of play with the principles in your mind and think through what are the questions we need to resolve here in the near term to make operations can work in outer space, I really think you'll come up with the same list that we have. So instead of sort of assuming this is going to go wrong or is going to be abused, I really challenge you, as Mike said, to think through those principles and think if there's really anything we could do other than come up with these kinds of arrangements with our partners. And the last thought is in terms of the multilateral process. Absolutely, multilateralism is incredibly important, but we are working with particular countries to do particular operations on the moon in cislunar space. And when we're going to engage in those particular operations, we do have to come up with a common set of rules so that we all know what we're doing together. So it's not that we don't want to do multilateral consultations, it's that we also, at the same time, do need to have a common set of understandings with our actual bilateral partners with whom we're doing operations. So that's the reason for the focus in the bilateral conversations. It's once again meeting those needs. It's not an attempt to shut down those other conversations that we are very much looking forward to. Thank you all for hosting this.
Yeah, Gabriel, thank you. And Mike, could I ask you for any final reflections?
Yeah, so thank you again to you, Steve, to McGill, and to my fellow panelists. This has been a robust and interesting conversation. Let me just end with where we began, with peace and avoiding conflict. That is the very first principle of the Accords. And we're going. NASA's going, Europe's going, Japan's going, our partners are going, private sector is going to the moon. This is happening. This is not academic. This is not theoretical. We need to get the rules in place now to avoid conflict, because if we allow the legal framework, if we allow the rules and regulations to fall behind the actual activities, that's when we get conflict. And that's what's our job as lawyers to help to try to avoid. So we need to move forward with the Accords and these bilateral discussions, as Gabriel just mentioned, to make sure that we're operating within the principles of the Outer Space Treaty and taking a step forward to implement those activities. But it isn't an either or, that we're doing that and that information will spur and inform the multilateral discussions where we can go to even more detail and create even greater global consensus. We need to establish an environment that's transparent, that's safe, and that we can all agree on to keep the peace, to get science. You know, we're traveling to the moon, but our ultimate destination is
Mike, just repeat that last. Your ultimate destination is, you just cut out then?
Sorry. The Artemis program is taking us to the moon, but the ultimate destination of the Artemis Accords is a peaceful and prosperous future.
Thank you. I'm glad I asked you to repeat that because we were all left on tenterhooks there around the world. But thank you, Mike, for that. A few final reflections. Firstly, I think it's been a wonderful debate. I think this is one of many, many discussions in this area. And as I said at the beginning, there are many diverse views and many voices that we need to hear. But I think we can all agree, all 250 of you, that we've had 5 incredibly learned, wise, practical, and interesting voices. So I don't know how we do this, but congratulations and thanks to all of them. Thank you all the panelists for making the time. Thank you so much to the Institute of Air and Space Law at McGill and the International Association for Advancement of Space Safety. I should have said at the beginning, and of course I've failed in my duty, that they have been cooperating for 10 to 15 years and have produced a lot of interesting work. They now have a series of webinars. This is the first. The next webinar, put it in your diary, ladies and gentlemen, it'll be great. It's going to be on the 31st of July. The topic will be, quote, the quest for a legal frontier between airspace and outer space. I can't wait. It'll be thrilling, no doubt. Also, the organisers are going to send all of the audience, I don't know how that happens, but a feedback possibility, a feedback form on Google Docs. And so please give the organisers your feedback, and because they want to make sure that the webinars just get better and better. It's now at my time 2:15 in the morning, so I think I'm going to go to bed shortly. But thank you all for staying with us all. I think it's been a fantastic webinar. Thank you to the organisers. Thank you to the panelists. And I think even if there are disagreements along the way, Mike's final words about peace, I think are a common feeling that we all have. So in these troubled times, stay safe and stay peaceful, and we shall all meet again very soon. Thank you to everybody, and I now close the webinar. Thank you.
Thank you so much.
Thank you. Wonderful.
Thank you.
Yeah.
Bye-bye. All the best, everybody.
Bye-bye.
Get some sleep.